All right, gun owners, we need to talk because the Supreme Court just made a move that half the country missed. And it's a big one. No, they didn't hold a press conference or wave flags. They just quietly dropped a decision that says more than any headline ever could. And if you care about where your rights actually stand, you might want to sit down for this. See, this wasn't a win or lose kind of week. It was a pay attention or get blindsided kind of week, because the justices didn't just rule on one case. They started drawing lines that decide how far the Second Amendment really reaches. Some of it's good news, some of it not so much. But every line they drew points to one thing. The court just sent gun owners a message. Clear, calculated, and maybe a little uncomfortable. So stay right here, because once you hear it, you'll never read the Constitution the same way again. All United States v. Rahimi, Gun Rights and Domestic Violence. Ruling right, let's kick it off with the case that made half the headlines and confused the other half. United States versus Rahimi. Now, this one's about a guy under a domestic violence restraining order who decided that still meant range day. The Supreme Court said nope, 8-1. They ruled that yes, if you're legally flagged as a credible threat to someone else's safety, the government can temporarily take your guns. And before anybody yells, they're coming for us. The court didn't say, your rights vanish. They said, common sense still counts. If you're dangerous, you sit out for a bit. If not, the right stays yours. So, what's the message? Pretty simple. The justices are done with people weaponizing chaos to test boundaries. They want the Second Amendment respected, but they also want you to keep it clean. And honestly, that's not tyranny. That's adult supervision. Next up, Garland versus Garland v. Cargill. Supreme Court overturns ATF bump stock ban Cargill. This one's where the Supreme Court basically told the ATF, nice try, but you don't get to rewrite laws just because you feel like it. The case was about bump stocks. Those controversial add-ons that make semi-autos fire faster. The ATF decided all on its own that meant machine guns. The court wasn't having it. Justice Thomas laid it out plain. A semi-auto is still a semi-auto because you have to pull the trigger every time. Period. Translation. Agencies don't get to make up new laws because Congress is slow or asleep. If you want to ban something, pass a bill. Otherwise, hands off. And just like that, bump stocks went from federal felony to legal again. That's not chaos. That's the court reminding bureaucrats who's actually in charge, because apparently the Constitution needed to file an HR complaint. All right. So, Vanderstock v. Garland. Supreme Court rules on ghost guns. After telling the ATF to stay in its lane, the Supreme Court turned around and said, but hey, some rules do make sense. Welcome to Vandertoe versus Garland, aka the ghost gun case. If you've seen the kits, order a box online, grab a drill, and boom, you've got yourself a working firearm faster than you can say background check. The court looked at that and basically said, yeah, no. They ruled that these kits can be regulated because they're readily convertible into functional guns. Translation, if it walks like a gun, talks like a gun, and fires like a gun, it's a gun. Justice Gorsuch made it clear. This isn't about banning creativity. It's about closing a loophole big enough to fit a gun show through. So sure, the ATF got slapped in one case, but this time, the court handed them the keys back. Call it tough love with a trigger guard. Now this one's wild. Mexico versus Smith and Mexico v. Smith and Wesson. Supreme Court blocks foreign lawsuit Wesson brands. Yep. An entire country tried to sue American gun manufacturers for crimes happening in Mexico. Their argument, U.S. companies allowed weapons to flow south and fuel cartel violence. The court took one look and said, nice try, but that's not how any of this works. They shut it down unanimously. Why? Because there's this little thing called the Protection of Lawful Commerce and Arms Act, which shields manufacturers when criminals misuse their guns. In short, you can't blame Ford when someone robs a bank with a Mustang. Just as Kagan said it best, Indifference isn't the same as involvement. So, Mexico walked in with a blame game and walked out with a reality check. Lesson learned. Don't drag American courts into your backyard problems, especially when the Constitution's on the defense team. Now, AR-15 and magazine bans. Supreme Court's silent move. Here's where things get real interesting. Because while everyone was busy arguing about bump stocks and ghost guns, the Supreme Court quietly sidestepped one of the biggest landmines in modern gun law, AR-15 and magazine bans. Two states, Maryland and Rhode Island, begged the court to let them keep their restrictions. The justices, they passed, didn't reject them, didn't accept them, just waited. But don't mistake silence for surrender. Justice Kavanaugh dropped a little breadcrumb. He said these bans might not hold up when the right case lands on the docket. And you know what that means? The fight's already circling back. So, yeah, for now those bans still stand. But make no mistake, the court's not done with this one. They're just loading the next round. And just when you thought the fireworks were over, Hawaii decided Hawaii carry ban. Supreme Court to decide private property rule to light another fuse. Here's the setup. The state passed a rule saying you can't carry a gun on private property unless the owner explicitly says you can. No sign, no permission, no carry. Sounds harmless, right? Wrong. Because that basically makes everywhere off limits. Restaurants, stores, even parking lots, it's not a carry restriction, it's a blanket ban dressed up in polite paperwork. So now, the Supreme Court's stepping in to figure out if states can pull that stunt. The question's simple. Does your right to carry end where someone else's property line begins? The outcome could reshape how millions of Americans carry, not just in Hawaii, but nationwide. If the justices strike this down, gun-free zone might become a phrase we hear a lot less. All right, lower courts. After Bruin, confusion and mixed rulings. Here's where it gets tricky, because sometimes what the court doesn't say is louder than the rulings themselves. See, ever since the 2022 Bruin decision, lower courts have been doing legal gymnastics, trying to figure out what historical tradition actually means. Some judges treat it like a history class, others like a guessing game. In Rahim, the justices basically said, hey, relax, you don't need a carbon copy law from 1791 to make something constitutional. Translation: stop pretending we need muskets and powdered wigs for every ruling. But that opened a new can of worms. Now, every lower court's trying to figure out how similar is similar enough. One judge in Texas says one thing, another in New York says the opposite, and gun owners are left wondering which map to follow. So, yeah, while the Supreme Court sets the tone, the echoes in the lower courts are chaotic. It's like the justices handed them the sheet music, and everyone's playing a different song. Let's park the legal talk for a minute. Because while 2025 gun laws, fast changes. Across the states the Supreme Court is busy quoting 18th century case law, you're the one dealing with the 21st century mess. And trust me, 2025 isn't exactly friendly terrain. State laws are flipping faster than campaign promises. One week your rifle's fine, the next week it's contraband because somebody didn't like how it looked too tactical. After brewing, a few states decided if they can't ban the guns, they'll just ban the places you can carry them. Parks, buses, parking lots, even grandma's bingo hall. Federal agencies still making it up as they go. A new president could flip policy overnight. Reciprocity one day, restrictions the next. Meanwhile, background checks crawl slower than a DMV line. Ammo prices look like stock charts. And hackers are leaking gun owner data like it's open season. And let's not forget theft, up everywhere. So while Washington argues over philosophy, your job's simple. Stay ready, stay informed, and don't hand them your rights on a silver platter. Now, let's talk survival. Not tactical, but legal survival guide. Stay compliant, stay protected legal. Because the courtroom battlefield isn't about firepower, it's about paperwork, timing, and knowing the rules before they're used against you. Step 1. Stay plugged in. If you're not checking your state's updates at least once a week, you're already behind. Laws are changing mid-sentence these days. Sign up for alerts from your Attorney General's office or trusted 2A groups. Go AFCAF, people who actually read the fine print so you don't have to. Step 2. Document everything. Serial numbers, purchase dates, receipts. Keep them backed up in 2 places. When laws shift overnight, the guy with the paperwork wins. Step 3. Secure storage isn't optional anymore. Buy a safe that's tougher than the opinions on Twitter. States are mandating it, and thieves are watching for the ones who don't. And last, expect delays. Play smart. Background checks move slower than politics. Don't wait until hunting season to realize you're still pending. Because in this climate, staying compliant isn't about paranoia. It's about staying one step ahead. That's how you keep your rights and your peace of mind. Let's be honest. Laws change. Responsible gun ownership. The real defense of freedom headlines fade, and courts swing like pendulums. But one thing that never shifts: how you handle your freedom. Owning a firearm isn't just a right, and it's a responsibility that follows you everywhere. Because at the end of the day, the Second Amendment doesn't just protect your gun, it reflects your discipline. So train like it matters. Store your firearms like your family's safety depends on it, because it does. Take the range days seriously. Teach someone younger what safety really means. Every responsible gun owner chips away at the stigma the media loves to paint. And here's the truth. No one says out loud, the best defense for the Second Amendment isn't sitting in Congress or the Supreme Court. It's sitting in your gun safe, owned by someone who actually knows what they're doing. Freedom works when people respect it. Be that person. Lead by example. Because the courtroom battles might decide the law, but how we live decides whether those rights survive. So that's where things stand. A supreme final thoughts. Supreme Court, gun rights, and what's next court that's finally drawing lines. Agencies that just got slapped on the wrist and gun owners caught in the middle trying to keep up. You know what's crazy? The biggest shifts in American gun law aren't happening in rallies or press rooms. They're happening quietly behind those marble walls, one ruling at a time. And that's why staying informed isn't optional anymore. Because if you don't know what changed, you'll find out the hard way. Usually with a letter, a fine, or a knock on the door. So here's the deal. If this breakdown helped clear the fog, hit subscribe, tap like, and drop your thoughts below. Do you think the court finally drew the line, or are we just getting started? Because the next decision could tighten the leash or snap it completely. Stay alert, stay responsible, and as always, stay free.